They say blood is thicker than water, but throw a lucrative piece of real estate into the mix, and that blood turns toxic faster than you can blink. I spent my entire adult life keeping my family from tearing each other apart, only for them to report me to the state bar, attempting to destroy my life just to steal my grandfather's legacy. My name is Harper. For the last 12 years, I have worked as a senior paralegal at a mid-sized corporate litigation firm in Chicago. I am not an attorney. I have never claimed to be an attorney. I never took the LSAT. I never went to law school. And I have always been fiercely careful about the boundaries of my profession. In the legal world, crossing the line into the unauthorized practice of law, UPL, is a career death sentence. It is a line I respected with religious fervor, at work anyway. But in my family, the lines were always blurred. The Pendleton family dynamic was one of perpetual, simmering chaos. If my Aunt Beatrice was breathing, she was complaining. If my cousin Leo, her only son, was talking, he was scheming. My mother, Claire, was the peacekeeper, a gentlewoman who despised conflict to a fault. And because I was the only one in the family who knew how to read a contract, negotiate a dispute, or file a simple piece of paperwork without having a nervous breakdown, I became the unofficial family fixer. Whenever someone had a landlord issue, a car insurance dispute, or a question about a contractor's estimate, they came to me. "Harper will look at it," was the family motto. I was happy to help. I loved my family, despite their flaws, and I genuinely believed that my organizational skills and understanding of basic civil processes were keeping us bound together. Everything changed when my grandfather, Arthur Pendleton Sr., passed away in the dead of winter. Grandpa Arthur wasn't a wealthy man in the traditional sense. He was a retired machinist who lived a quiet, frugal life. But what he did have was property. Decades ago, he purchased 40 acres of heavily wooded land bordering a pristine, undeveloped lake in upstate Wisconsin. Over the years, the surrounding areas had been gentrified, bought up by luxury developers, transforming Grandpa's rustic retreat into a multi-million-dollar gold mine. When the funeral concluded and the initial wave of grief subsided, the ugly reality of his estate reared its head. Grandpa Arthur had left a will, but it was a disaster. It was a handwritten document, a holographic will, dated 15 years prior, kept in a rusty lockbox under his bed. It wasn't notarized, and the language was beautifully sentimental, but legally terrifying. He left the property to his loving daughters, Beatrice and Claire, to be shared by the bloodline forever, never to be sold to strangers. The ink was barely dry on the death certificate before the vultures started circling. A prominent real estate development group, Oak and River Holdings, caught wind of his passing. Within 2 weeks, they slipped a cash offer into Aunt Beatrice's mailbox that made her eyes roll back in her head. $4.2 million. Suddenly, Grandpa's dying wish of keeping the land in the family was entirely forgotten by Beatrice and Leo. They wanted the money, and they wanted it immediately. Leo, who had a string of failed tech startups and a mountain of hidden debt, was practically salivating. My mother, however, was heartbroken. She wanted to keep the land, honor her father's wishes, and pass it down. The family was fracturing. The Thanksgiving following his death was a nightmare of passive-aggressive comments, slammed doors, and outright screaming matches. Aunt Beatrice threatened to take my mother to probate court to force a partition sale, an agonizing and expensive legal process that would bleed the estate dry and force the sale of the land anyway. My mother was terrified, weeping in the kitchen, convinced she was going to lose her father's home and her sister in one fell swoop. That was the moment I made the biggest mistake of my life. I stepped in. We don't need to throw away hundreds of thousands of dollars on probate lawyers fighting each other, I told them all, standing at the head of the dining room table. We can figure this out internally. Leo scoffed, swirling a glass of cheap scotch. And how do you propose we do that, Harper? You gonna paralegal us out of a $4 million deal? No, I replied, keeping my voice terrifyingly calm. I'm going to mediate. We're going to sit down, as adults, and figure out a compromise. Over the next 3 days, I essentially locked my family in the living room. I facilitated hours of grueling, emotional negotiations. I played therapist, referee, and translator. Finally, we reached a fragile compromise. The agreement was this. The family would hold the property for a minimum of 5 years. During that time, they would lease a portion of the timber rights to generate immediate passive income, enough to pay off Leo's pressing debts and satiate Beatrice's greed. If, after 5 years, Beatrice still wanted to sell, my mother would have the right of first refusal to buy out her half at a fair market value determined by an independent appraiser, not a developer. It was a brilliant compromise. Everyone was exhausted, but everyone agreed. To ensure nobody conveniently forgot the terms of our verbal ceasefire, I went to my laptop and drafted a document. I titled it, Memorandum of Family Understanding and Intent. I was painstakingly careful. At the very top of the document, in bold, capitalized letters, I wrote, Disclaimer. Harper Brooks is acting solely as a familial mediator. She is not a licensed attorney. This document does not constitute legal advice, nor is it intended to be a formal legal contract prepared by legal counsel. It is a mutual record of intent agreed upon by the undersigned. I printed it out. Beatrice signed it. My mother signed it. Leo, acting as a witness for his mother, signed it. We hugged. We cried. I thought I had saved my family. I had no idea I had just handed them the weapon they would use to execute me. For 8 months, there was peace. The timber lease was signed, generating a modest but steady revenue stream. My mother spent her weekends at the cabin, tending to Grandpa Arthur's gardens, while Beatrice and Leo stayed away, perfectly content to cash their monthly dividend checks. I returned to Chicago, buried myself in my firm's litigation files, and felt a profound sense of pride. I had used my skills to protect my mother and honor my grandfather. Then, Oak and River Holdings came back. This time, they weren't offering $4 million. They were offering $7. They had secured zoning permits for a luxury eco-resort on the adjacent properties, but they desperately needed our lake frontage to make the project viable. $7 million in cold, hard cash. The moment Beatrice heard the number, the memorandum of understanding ceased to exist in her mind. She and Leo immediately contacted Oak and River, signaling their intent to force a sale of the property. When the developer's lawyers began running title checks and due diligence, they inevitably hit a roadblock: my mother. She held a 50% stake, and she absolutely refused to sign the sale agreement, invoking the 5-year holding period we had agreed upon. Beatrice was furious. Leo was desperate. His creditors had caught up with him, and a few $1,000s from timber rights wasn't going to save him from bankruptcy. They needed to force my mother's hand. But because of the memorandum I had drafted, my mother had grounds to file an injunction to stall any forced partition sale. The document, while informal, proved a prior contractual intent that a probate judge would likely want to review, dragging the process out for years, time that Oak and River wasn't willing to wait. Beatrice and Leo realized that to get their millions, they didn't just have to defeat my mother. They had to invalidate the memorandum entirely. And to do that, they had to destroy the person who wrote it. They hired a lawyer named Richard Sterling. Sterling was notorious in the upstate New York legal circuit. He wasn't just a bulldog, he was a shark who thrived in the muddy waters of familial estates. He was expensive, aggressive, and entirely devoid of a moral compass. I didn't know any of this was happening until a dreary Tuesday afternoon in November. I was sitting at my desk in Chicago, reviewing discovery documents for a corporate merger, when the receptionist buzzed my line. "Harper, there's a courier down here for you. He says it's personal and requires a direct signature." Assuming it was a late birthday gift from my mother, I jogged down to the lobby. A bored-looking man in a windbreaker handed me a thick, rigid envelope. I signed for it, tore the cardboard tab, and pulled out a stack of heavy stock paper. The header on the first page made the air leave my lungs. The State Bar of Illinois, Attorney Registration and Disciplinary Commission, Notice of Investigation. My hands began to tremble. I scanned the dense legal text. Formal complaint filed against Harper Brooks. Allegations of the unauthorized practice of law, UPL. Drafting legally binding instruments without a license, providing unlicensed legal counsel, manipulating vulnerable parties in an estate dispute. Attached to the bar notice was a copy of the formal complaint. The complainants listed were Beatrice Pendleton and Leo Pendleton. I felt physically sick. The lobby spun around me. My own aunt and cousin had reported me to the state bar. I rushed back to my office, locked the door, and read the complaint in its entirety. It was a masterclass in fiction, penned undoubtedly by Richard Sterling. The complaint alleged that I had preyed upon the emotional vulnerability of grieving family members. It claimed that I had falsely presented myself as a legal authority, forced them into an oppressive contract, and drafted a fraudulent legal instrument designed to manipulate the estate in favor of my mother. They had attached a copy of the memorandum I drafted, but the copy attached to the complaint was altered. The entire first paragraph, the bold disclaimer explicitly stating I was not an attorney and was not giving legal advice, was gone. They had cleanly removed it, presenting the rest of the document as me impersonating a lawyer drafting a binding contract. The implications were catastrophic. In Illinois, the unauthorized practice of law is not just a slap on the wrist. It is a serious offense that can result in massive fines, civil liability, and in severe cases, criminal misdemeanor charges. But worse than that, it would end my career. No law firm would ever employ a paralegal who had a substantiated UPL ruling against them. My reputation, my livelihood, my entire identity was built on my professionalism. My phone vibrated on the desk. It was a text from Leo. "Should have stayed out of it, Harper. Tell Aunt Claire to sign the sale papers by Friday, and maybe we'll drop the complaint. Your choice." It was extortion, pure and simple. They were holding my career hostage to force my mother to sell our grandfather's legacy. I called my mother. When she picked up, she was already sobbing. Beatrice had called her 10 minutes prior, gloating, explaining exactly what they had done. "I'll sign it, Harper," my mother cried through the phone, her voice breaking. "I have to sign it. I won't let them ruin your life over a piece of land. I'll call their lawyer right now. I'm so sorry, baby. I'm so sorry." "Don't you dare sign a single thing," I hissed, a cold, unfamiliar fury settling into my bones. The panic that had gripped me in the lobby was evaporating, replaced by a razor-sharp, icy rage. I had spent 12 years working alongside some of the most ruthless litigators in the Midwest. I knew how to build a case. I knew how to find the cracks in a lie. "Mum, listen to me," I said, my voice eerily calm. "Do not speak to Beatrice. Do not answer Leo's texts. And absolutely do not call Richard Sterling. You let me handle this." "But the Bar Association. I am going to destroy them," I promised her. I hung up the phone and looked back down at the notice of investigation. The disciplinary hearing was set for a preliminary review in front of an administrative law judge for the bar, a man named Judge Harrison Davies. I had exactly 3 weeks to prepare. Aunt Beatrice and Cousin Leo thought they were playing chess against a naive, overly helpful niece. They thought the threat of the state bar would make me fold. They forgot one crucial detail. I didn't just type documents for a living. For over a decade, my job had been to hunt down liars, frauds, and extortionists in discovery, and hand them to the trial partners on a silver platter. They wanted a legal war. They were about to learn exactly why I was the best paralegal in Chicago. I didn't sleep that night. I sat at my dining room table, surrounded by empty coffee mugs, my laptop glowing in the dark. If Beatrice, Leo, and their attack dog lawyer, Richard Sterling, wanted to drag me into the mud, they were going to learn that I practically lived in the dirt of corporate litigation. My first call the next morning was to Thomas Aris. Thomas was a senior managing partner at my firm, a man with 30 years of litigation experience, a reputation that made opposing counsel sweat, and, most importantly, my mentor. When I walked into his corner office and dropped the Bar Association's notice of investigation onto his mahogany desk, his eyebrows hit his hairline. Thomas read through the complaint in utter silence. When he reached the altered memorandum, his jaw tightened. When I showed him the extortion text message from Leo on my phone, his eyes went flat and cold. "Harper," Thomas said, leaning back in his leather chair, "this isn't just a frivolous, unauthorized practice of law complaint. Submitting an intentionally altered document to a state disciplinary board is fraud. Using that board to compel a real estate transaction is extortion. They haven't just crossed a line, they've leaped over it with a flare gun." "I need your help, Thomas," I said, my voice finally cracking under the weight of the last 24 hours. "I don't just want to defend my license. I want to hold them accountable. If my mother signs that deed to save me, it will destroy her." Thomas didn't hesitate. "I'm representing you, pro bono, and we are going to bury them." We immediately went to work, treating my family exactly as we would treat a hostile corporate entity. Step 1. The digital paper trail. The cornerstone of Richard Sterling's complaint was the altered memorandum of understanding. They had submitted a physical, printed copy with my disclaimer cleanly sliced off, but they fundamentally misunderstood how digital evidence works. I hadn't just handed them a piece of paper. I had emailed the original PDF to both Beatrice and Leo the night we agreed to the terms, so they would have it for their records. Thomas subpoenaed my own firm's IT department to extract the server-level email logs. We didn't just print the email, we extracted the cryptographic hash and the exact metadata of the PDF attachment sent on that November evening. The metadata proved undeniably that the document I sent contained the bolded legal disclaimer at the very top. It proved the document attached to their bar complaint was a forgery. Step 2. The financial motive. I needed to know why Leo was acting with such reckless, criminal desperation. I spent an entire weekend running background checks, pulling public dockets, and digging through civil filings in Leo's home county in upstate New York. What I found was staggering. Leo wasn't just in debt, he was facing a civil lawsuit from a private, hard-money lending group notorious for predatory practices. He owed them $450,000, and they had just secured a default judgment against him. Furthermore, his own mother, Beatrice, had co-signed the disastrous loan. If they didn't get their hands on the Oak and River money immediately, they were both going to lose their homes. They were drowning, and I was the only thing standing between them and the surface. Step 3. The extortion trap. Leo's text message. Tell Aunt Claire to sign the sale papers, and maybe we'll drop the complaint," was the smoking gun. But Thomas and I wanted to make it absolutely airtight. Under Thomas's guidance, I texted Leo back. "Harper. Leo, I'm terrified of losing my career over this bar complaint. If I can convince my mum to sign the Oak and River release, can you guarantee Sterling will withdraw the ARDC complaint immediately? I need to know this goes away." I stared at the glowing screen of my phone, my heart pounding in my chest. 10 minutes passed, then 20. Finally, my phone buzzed. "Leo, you get Claire to sign the contract with the developers by Friday noon. Once the escrow is funded, Sterling will officially withdraw the complaint and tell the bar it was a family misunderstanding. We have a deal." Thomas, reading over my shoulder, let out a low whistle. He just put the extortion in writing, explicitly tied his legal counsel to it, and hit send. "Harper, it almost takes the fun out of destroying them when they make it this easy." We spent the next week drafting our response. We didn't just deny the allegations. We filed a comprehensive 100-page counter-dossier to the administrative law judge. We included the forensic email analysis, the public records of Leo's crippling debts, the unedited text exchanges, and a sworn affidavit from my mother detailing Beatrice's harassing phone calls. We were ready for war. The disciplinary hearing took place in a sterile, fluorescent-lit conference room at the State Bar headquarters in downtown Chicago. Administrative Law Judge Harrison Davies presided. He was a stern, 60-something man with wire-rimmed glasses and a reputation for possessing zero tolerance for nonsense. Aunt Beatrice and Cousin Leo sat across the heavy oak table from us, flanking their attorney, Richard Sterling. Beatrice wore a conservative navy suit, dabbing her dry eyes with a tissue, playing the role of the aggrieved, manipulated widow to perfection. Leo sat with his arms crossed, shooting me smug, venomous glares. Sterling looked supremely confident, adjusting his expensive silk tie. They thought they had backed a terrified paralegal into a corner. Judge Davies opened a thick manila folder. "We are here for a preliminary review of ARDC complaint 409-B against Ms. Harper Brooks regarding the unauthorized practice of law. Mr. Sterling, you represent the complainants. You may proceed." Sterling stood, buttoning his jacket. He spent 15 minutes spinning a masterful, tragic tale. He painted me as a cold, calculating legal operative who had used my professional knowledge to hijack a grieving family's estate. "Your Honor," Sterling concluded, gesturing dramatically toward the altered document projected on the screen behind him. Ms. Brooks drafted a legally binding contract, which she had no license to do, to lock my clients into an oppressive real estate arrangement, effectively stealing millions of dollars in equity from her own flesh and blood. The document speaks for itself. We ask that the board proceed with formal disciplinary charges and refer this matter to the state's attorney. Beatrice let out a perfectly timed, dramatic sob. Judge Davies nodded slowly, making a note on his legal pad. Then he turned his gaze to our side of the table. "Mr. Orris, I see you've stepped down from your ivory tower to defend your paralegal. What say you?" Thomas stood up slowly, calmly adjusting his cuffs. "Your Honor, Mr. Sterling is absolutely correct about one thing. The document does indeed speak for itself. The problem is, the document Mr. Sterling submitted to this board has had its tongue cut out." Sterling frowned. "Objection. Theatrical rhetoric." "Overruled," Judge Davies grunted. "Get to the point, counsel." Thomas signaled me. I handed him our first exhibit binder, which he passed to the judge. "Your Honor, Exhibit A is the original, forensically verified, PDF metadata log of the exact document Ms. Brooks drafted, sent via her personal email to the complainants. If you turn to page 3, you will see the actual document." Judge Davies flipped the page. His eyes narrowed. He looked up at Sterling, then back at the page. There is a bold disclaimer here, explicitly stating Ms. Brooks is not an attorney and is not providing legal advice. Sterling's confident posture faltered. Your Honor, my clients provided me with the printed document they received. Save it, Mr. Sterling, Thomas interrupted, his voice ringing with authority. Let's move to Exhibit B, the text messages. Thomas handed over the second binder. Ms. Brooks is not the one manipulating a family estate. The complainants, motivated by massive, undisclosed financial liabilities detailed in Exhibit C, have weaponized this disciplinary board to extort Ms. Brooks. They threatened to destroy her career unless she forced her mother to sell the estate to Oak and River Holdings. Judge Davies read the text messages. The silence in the room became absolute, suffocating, and terrifying. I watched the color drain completely from Leo's face. Beatrice stopped dabbing her eyes. The tissue hung limp in her trembling hand. Sterling leaned over to read the texts in the binder. I saw the exact moment his soul left his body. He realized his clients had kept him entirely in the dark about their extortion tactics. But worse, his name was now explicitly tied to an illegal scheme on the official bar record. Judge Davies took off his wire-rimmed glasses and set them deliberately on the table. When he spoke, his voice was deathly quiet, laced with an anger so profound it made the air vibrate. Mr. Sterling, Judge Davies said, are you aware that submitting fraudulently altered evidence to this tribunal is a violation of Rule 3.3 of the Rules of Professional Conduct? Are you further aware that using the threat of disciplinary action to gain an advantage in a civil matter is a direct violation of Rule 8.4? Your Honor, Sterling stammered, sweat beading on his forehead. I had no knowledge. My clients provided the physical. I have not seen those texts. You represent them, Judge Davies roared, slamming his hand on the table. Beatrice jumped violently in her seat. You brought this garbage into my jurisdiction. You allowed your clients to use this esteemed board as a crowbar for real estate extortion. We withdraw the complaint, Leo blurted out, panic completely taking over. We drop it. We don't want to pursue this anymore. Judge Davies turned his lethal gaze to my cousin. You don't run this room, Mr. Pendleton. You don't get to fire a loaded gun and then ask for the bullet back because you missed. The judge picked up his gavel but didn't strike it. He just gripped it tightly. The complaint against Ms. Harper Brooks is dismissed with prejudice. Ms. Brooks, I apologize on behalf of the State Bar that you were subjected to this malicious charade. You acted with complete professional integrity. I exhaled a breath I felt like I had been holding for 3 weeks. I looked at Thomas, who gave me a small, satisfied nod. As for you, Mr. Sterling, Judge Davies continued, his voice dropping to a terrifying growl, I am immediately referring your conduct to the Attorney Registration and Disciplinary Commission for a full ethical review, and I will be forwarding a transcript of today's hearing, along with these text messages, to the Cook County State's Attorney's Office for a review of potential criminal extortion charges against your clients. We are adjourned. The aftermath was a bloodbath, just not the one Beatrice and Leo had planned. Oak and River Holdings caught wind of the legal radioactive fallout surrounding the property and immediately pulled their $7 million offer, wanting nothing to do with an estate tied up in extortion investigations. The hard money lenders foreclosed on Beatrice's home to satisfy Leo's debts. Sterling, facing disbarment for his failure to vet the altered documents, dropped them as clients and sent them a massive bill for his time. My mother never had to sell the lake property. It remains exactly as my grandfather intended, surrounded by quiet woods, untainted by luxury developers, and deeply peaceful. We don't invite Beatrice or Leo to Thanksgiving anymore. Blood may be thicker than water, but truth is absolute iron. My grandfather's land remains untouched, a quiet sanctuary safe from the greed that nearly tore us apart. My career survived, stronger than before. Beatrice and Leo got nothing but legal bills and ruined reputations. Sometimes, the most powerful thing you can do when someone tries to bury you is to prove you own the shovel.